So just running through the agenda for today's call. I'll just move on to the next slide if it'll let me. There we go. First of all, I will say a few words on where we are now. Certainly you wouldn't want to start from here, so to speak, but where we are now, a bit of scene setting. Then George and Lisa, between them, will talk on some particular transactional and contentious issues and how to address the situation of where we find ourselves now. And then I will turn to some administrative logistical challenges, what we're facing as to how to get deals done, how to work around producing documents, getting signatures, all that kind of thing. So that's our plan for now. So I will first start off with a bit of scene setting. Well, there is no doubt that the nature of the situation is unique. I don't think any of us have faced anything like this before. They are very challenging times that we are in. As a real estate industry, we are very used to downturns and bull markets and bear markets. And those who've been in the real estate industry for a long time will simply say, oh, yes, of course, it is a cyclical business, absolutely. But this isn't just an ordinary downturn. This is, at present, bordering on complete social shutdown and great swathes of economic shutdown. So the nature of the situation is truly extraordinary and far greater than perhaps we have seen before. In an ordinary downturn, people keep spending to some degree. They go to pubs and restaurants and clubs and theatres to cheer themselves up. They continue to go to work while they have work in offices and factories and endeavour to drum up business and come up with new products in order to survive. And then they travel for fun and holiday and to see family. And all of that, of course, is now limited in the situation we find ourselves in. Even the price of gold has started to fall in recent days because investors are now believing that there is no safe haven from this all-pervading crisis. So if you're not investing in gold, perhaps you're investing in hand sanitizer and masks and perhaps the humble loo roll. This is a huge demand on us, a huge challenge, uncharted territory, and we have to look to see how we can make the best of where we are in. So what does this mean for the real estate market? We need a grand and a generous and a visionary response. We really need to come up with something new. We need to work collaboratively. We need to look beyond the us and them and to try and see through our way through this out to the other side. Absolutely, as tenants, we need to be ready to defend ourselves if necessary. We need to come up with strategic approaches to how we approach our situation. But much more than an individualized landlord versus tenant sort of right-based approach, we need something bigger than that. So we have to try not to fight about service charge and rents. We have to appreciate that as tenants, we may not be able to offload property that we no longer need. Assignment and underletting may just not happen because the market may just not be there. So we have to come up with different solutions to the problems that we face because the solutions for this situation won't be what we normally turn to in an ordinary downturn. If there is just too much fighting, then the only winner will be the coronavirus that put us in the situation to start with. It is a shared problem. This is not just one sector of the market or one country or even one continent. It is a shared problem across the world. Not all landlords have deep pockets. Not all tenants are big business looking to take advantage. And both sides have their duties to their shareholders, to their investors, to their employees, to those who work the shop floor, those who man the tills, those who are on reception, those who guard their security desks, their print room, their employer. So what we need is working together as an industry to produce sustainable solutions. And I think that's important to emphasize that this is not a sort of one shot and you're done approach to anything. Yesterday's press conference, the Prime Minister said that he hoped we would turn the tide on the virus within 12 weeks. And that's just turning the tide. So this is not just an issue for next week's March quarter day. It will undoubtedly also be an issue for the June quarter day and may well also continue towards the end of September and the September quarter day. And if coronavirus is typical of flu-like viruses, it may well peak again in the winter. So this is an issue that is worldwide and for a while, so we need sustainable solutions until we can achieve the herd immunity and the dying down of the pandemic that the scientists are hoping to achieve. So amongst all this doom and gloom, amongst the situation we are in, what can we do? Because it's good to be doing something rather than worrying about everything. And so we can all, either side of this industry, and whether we are occupier or landlord, agent or lawyer, advisor or retailer or office sector or logistics, we can all lobby for government action this day. Jam yesterday and jam tomorrow does not put food on the table today. And every business that we can get through this crisis is a win. Every storm that can be weathered by any employee, by any occupier, by any landlord, by any business, when we come out the other side of it, is a win. So we need immediate action, lobbying, working together to try and get everybody we can through this situation. So vision is not enough, though. If vision is not enough, then the other side don't share it, then vision is never enough. And we have to look to defend our issues and our situations and our positions. Vision is not enough if the other side don't share it, which is why we have Lisa as a real estate litigator on the phone. Right, I'm going to hand over to George and Lisa now to talk on our next topics. George?
Yes, so as Caroline says, we're all hopeful as an industry and as a society that government is going to be able to do things to help businesses survive, and that help is going to be immediate because there's clearly immediate issues that we all have to deal with and worry about. But on the other hand, also as lawyers, we also have to remember that quite often our job is the detail of what's in the documents and contracts that govern our relationships with landlords and suppliers and so on. So what we try to do is just come up with a list of things that are probably the most immediately relevant that might be facing us as occupiers of real estate. First one of those, keep open clauses, primarily for leisure and retail premises. If you are someone with a keep open clause in your lease, what is the likely impact of that on you now? And clearly businesses are having lots of pressures on them as to whether or not they can actually keep open, and that might be things like looking to protect your staff and social distancing concerns. It might be that staff are unwell and having to self-isolate, so you can't actually physically get staff. It might be issues in the supply chain, stock issues. So lots of reasons why a tenant might actually struggle to comply with a keep open clause, even if it wanted to. So the current situation is, of course, that the government hasn't actually imposed a restriction that says shops must close, that says leisure outlets must close. So our view is the current position is most keep open clauses are not actually tenants are not going to be able to benefit from the sort of standard exceptions in a keep open clause. If that changes, if the government does actually impose restrictions to the extent of saying you may not keep open, you have to close, then almost all keep open clauses have a standard provision saying the tenant doesn't have to stay open if it's not lawful or breach of some statutory regulation. So in that situation, you would not be in breach of your lease. But as things stand, regardless of the moral imperative, whichever way people fall on that, you almost certainly would be in breach if you chose to close. However, that said, it does seem pretty unlikely that a landlord would actually have a lot of appetite to do anything about any breach of a keep open clause now. It's a well-known position that for a landlord to actually get an injunction to force people to stay open is extremely difficult and very unlikely to succeed. Strictly speaking, a landlord could forfeit and try and terminate the lease if there's a breach of it, keep open. But if ever there was a time when landlords don't want to try and be letting vacant units, then now must be it. So commercially, it seems extremely unlikely that a landlord would ever seek to forfeit. What we have seen, actually, though, is people asking for new exemptions to go into keep open clauses. So we've seen some people in the market for deals that they haven't yet signed asking for a specific widening of the keep open exemption to include coronavirus or possibly any mutation of the coronavirus. People thinking, well, what happens if another one comes along in 5 years' time? Now, obviously, keep open covenants are very closely linked to turnover rents. So if the lease does contain a turnover rent top-up, then the keep open clause will be tied into that. So if you are closing in breach of your keep open, then it's almost certainly the case that you will have triggered one of the clauses that entitles the landlord to charge a sum in lieu of the turnover rent that would otherwise have been generated. Now, again, one would hope that in light of the current situation, landlords are unlikely to try and enforce such a penalty clause. It would certainly be a very aggressive stance to take, and in the current market, in the current position, and I can see that it also potentially wouldn't actually be in the landlord's long-term interest to aggressively pursue an occupier for short-term, relatively small sums of money. It doesn't say much for trying to preserve the long-term health of that occupier or tenant. So our view is that's certainly something where we would expect there to hopefully be cooperation and conversation between landlords and tenants over keep opens generally, but also what's happening with turnover rents. Lisa, do you want to pick up on when rent suspension provisions might apply?
Yeah, sure. And this is a question I've been asked a lot about in the last 24, 48 hours about some tenants, do I need to pay my rent? Well, the starting point is yes. Rent payable under lease is generally irrespective of anything else, subject to the exceptions I'm going to come on to. And most leases, there's a few exceptions, but most leases have what we call anti-set-off clauses. So even if the tenant has some kind of claim against the landlord, that doesn't excuse the tenant from having to pay its rent. It can't set off its claim against the landlord against its obligation to pay rent. So generally speaking, rent is payable. Does the rent suspension clause apply, though? Well, you need to read that carefully in relation to each individual lease. Most rent suspension clauses only cause rent to be suspended in circumstances where there's damage or destruction to premises. It doesn't specifically relate to the circumstances that we see here, where the premises aren't damaged. They may be simply unusable in the sense that the government, well, it hasn't done it yet, of course, but if there was actually a shutdown and a legislative imposition such that one couldn't use the premises. But most rent settle clauses don't go that far. I'm sure in the future the drafting of those clauses will probably change and widen, but at the moment that's not the case. So in many leases, the rent suspension clause just simply isn't going to be helpful for tenants. But as I say, as a tenant, you need to have a look at that clause carefully, because if it's wide enough, you may well be able to use it. It's also worth having a bit of a think about service charge as well. There may be some argument that service charge isn't payable. For instance, services probably aren't going to be provided, so it may just simply not be an issue at all. But generally speaking, service charges will fall into the same category and will be payable. I think it's also worth thinking about the implications if you decide not to pay either rent or service charge, because, of course, there are implications and actions that landlords can take. Now, they may or may not take those actions in the current climate. One option, as George alluded to earlier, was forfeiture. So if a landlord takes action to forfeit a lease, obviously it brings it to an end, and unlikely in this climate that they would do that. If they did, if you chose not to pay rent and a landlord did, however, forfeit, the answer to that is you would apply for relief from forfeiture, but to obtain relief, you would have to pay the rent and the landlord's costs to get the lease back, essentially. Of course, other options for landlords are the use of what's called CRA, which is essentially where landlords can serve a notice 7 days in advance saying you haven't paid your rent. Unless you pay it within the next 7 days, we will enter the properties and seize goods to the value of the debt. Now, that mechanism can only be used for rent rather than service charge. So that's, if you chose not to pay service charge, for instance, that recovery mechanism by the landlord isn't available to it. The other thing that a landlord may be able to do, of course, is serve a statutory demand or issue a winding up petition. In those circumstances, to avoid the adverse consequences of those particular actions on behalf of the landlord, of course, at that time as a tenant, you would potentially need to pay. There's a better argument with regard to service charge because you may be able to argue it's disputed. And lastly, of course, the landlord could issue proceedings for the rent as well, and you may need to pay, or you may be able to defend those proceedings depending upon the rent setter clause. But where we're in the situation we are now and the rent setter clause doesn't help you, it is quite difficult for a legitimate argument not to pay the rent. There are some arguments around frustration, the doctrine of frustration, which I'll come on to. But I'll hand over firstly to George just to talk about agreements for lease, and then we'll come on to that other specific remedy in a moment.
Thanks, Lisa. Just actually a couple more points from me on rent suspension. So, as Lisa says, the lease won't allow for it. It's essentially going to be an issue for your business interruption insurance, and whether that covers it is very much going to depend upon the details of that policy, which is just going to vary from case to case. We have since seen clients looking to put new wording into their leases to allow for a rent suspension in the event that they are unable to open or trade or use their premises, office premises, due to coronavirus issues. So I think that very much will potentially be coming into the market. And of course, we've seen lots of occupiers approaching their landlords asking for anything ranging from rent holidays, rent concessions to paying monthly if they can't already pay monthly. So it's simply a case of trying to have a conversation and get the landlord to support you as a business. So moving on to an agreement for lease, can I get out of it? And this might happen if you've exchanged to take a property in more certain times, and that agreement is still running, and clearly with how things are today, you might not have made that decision if you were asked the question all over again. So what can you do to get out of an agreement for lease? Well, the main issues really are going to be timing. It's very unlikely that anyone will have an agreement for lease which will have a clause which allows for termination in the event of pandemic, just as there were Brexit clauses were going into agreements for lease prior to the referendum result being known. So it will be about timing, and if there are long stop dates in the agreement that a landlord isn't able to meet because economic activity is going to slow down. And the two main things there are the planning process and then if there's building the space. So I'm sure many of you will have seen that Leeds City Council announced that it was stopping having any planning committee meetings for a 3-month period and was calling on the government to give it powers to operate planning committee by remote meetings, so telecoms, Skype meetings, but clearly anything that is conditional on planning, that is all going to slow down. And even if it's not the planning committee, you might find that a planning officer who is dealing with the particular case is self-isolating, and that there will be shortages of staff in what are already overstretched planning departments. And a standard time extension in an agreement for lease isn't going to anticipate this. Although, again, this is something where we've seen clients trying to build extensions for the planning period in if there is a delay because committee meetings are postponed and so forth. So if you get past that long stop date, planning hasn't arrived, and if the reason it hasn't arrived in time is because the planning committee simply didn't meet, then you are likely to be able to terminate. Same applies for practical completion long stop. Usually long stop dates will have an extension if there is a force majeure event, and depending on the wording of the building contract or the agreement, force majeure may well cover the current situation, but equally almost all agreement for leases will also have a hard long stop date that doesn't push out again, and those are the dates that are particularly going to be at risk. We've heard reports of building contractors essentially saying that in order to protect their staff, their workforce, that they can't continue working on site, and especially potentially if some of those workforce are non-UK nationals and looking to return to their original homes. So that is putting landlords carrying out works under pressure and concerned about hitting those dates. So that is something to keep a watching brief on. Lisa, do you want to pick up on points around frustration?
I've lost one of the connections on my screen.
Lisa, we can hear you. Are you there still?
Yes, it's just I've lost the connection on my computer, but as long as you can hear me on the phone, that's amazing.
Well, Lisa, I'll tell you that your slide point says frustration, so you can talk to that.
That's fine. I will press on with that. So one of the other questions I've been asked by a number of clients recently is whether the lease whether one can argue that the lease has been frustrated. So frustration is a document that really relates to where you have supervening events which are so unusual and unforeseen that it could be argued that the performance of the contract can't really take place in a way which everybody anticipated at the outset. Now, most case law relating to frustration is all in the arena of shipping cases, so it's certainly not property cases. And as I say, there's very little case law on the issue. There was a case in Hong Kong in 2003 following the SARS outbreak. And I'm not going to try and pronounce the case name because it will be poorly pronounced. But basically what essentially happened is that the tenant had to vacate their flat as a result of an order from the Department of Health, an isolation order for 10 days. And the tenant claims that off the back of that, the lease could be terminated and didn't have to pay rent. The landlord said, well, no, that's not the case, and brought a claim for the non-payment of rent. And the court actually went back to a House of Lords decision, as it was called at the time in the UK, and said that frustration of a lease can't occur unless outstanding performance of the contract in accordance with its terms differs significantly from what the parties reasonably contemplated. And here, the isolation order had only been for 10 days. And the fact that the tenant actually was fearful of the situation and effectively took themselves out of the block of flats for far longer wasn't relevant to the legal position. So essentially, the court was saying, look, this is a 10-day intervention, and it certainly didn't have the implication of frustration of the lease. Now, the only other useful case law that we've got, and some of you will be familiar with it, is the case in Canary Wharf in 2019, which dealt with the effects of Brexit. And in this particular case, the tenant was an EU agency whose lease in Canary Wharf essentially had no practical benefit to them following the Brexit decision. And whilst it technically still occupied, the premises was effectively useless to it. And what the court said there was that, well, no, this still wasn't a case which would constitute frustration of the lease. It wasn't an unforeseeable event that Article 50 would be triggered, and it has always been an option for the government to enact effectively withdrawal from Europe. So where you get to with this, it's actually very unlikely that a court will order frustration of a lease such that a tenant doesn't need to pay its rent, unless the closure would be for a very long period or until the end of the lease. So this is potentially, and this we come on to really, what negotiation tactics that the tenants have. And there's an important one to consider around frustration, but it would be, in my view, difficult to successfully argue in many circumstances unless both the government legislated for closure of the type of premises in question, such that there was no choice, and that closure was for a very long period or effectively until the end of the lease. So it is a difficult one to argue for tenants, and we are effectively in unprecedented times, but because of that and because of the fact that we've not had a situation quite like this, there is some, I suppose, availability to argue, to raise an argument, but those arguments are going to be difficult except in very limited circumstances. Linked to that, I've been asked about, well, what if a landlord chooses to close a premises when a tenant is willing to remain open? Does the tenant have a claim against the landlord? Well, possibly is the answer to that. If the landlord closes in the circumstances where it has to close because of government intervention, it'd be very difficult for a tenant to bring a claim for all sorts of public policy reasons, let alone anything else. But if a landlord seeks to close a premises at its own decision, it is arguable at least, and all of these things of course depend on the facts, it's arguable at least that the tenant could have a claim against the landlord for what's called derogation from grant, i.e. you're taking something away which has been granted to you. You're taking away the tenant's ability to trade. What would the tenant use that as a mechanism for? It may be a lever for negotiation because the tenant is losing out. But of course, in most damages claims, one has to prove loss, and the tenant may not be able to show a significant degree of loss in circumstances where it wouldn't have made a lot of profit if it had been able to open. But it may be enough to constitute a counterclaim against the landlord's claim for non-payment of rent if the tenant chose to go down that route. So there are some options open for negotiation with landlords, tenants. Landlords are in a strong position in many respects because of the way in which up till now most leases have been drafted. But as George said, this is probably going to create work for transactional property lawyers to look at their precedents and actually be able, on behalf of each party, to change the negotiation of some of these key terms that have really been, to a certain extent, fairly boilerplate for many years. So that's all I was going to comment on that, Caroline.
Okay, thank you, Lisa. I'm going to move on now to some logistical challenges. This is the last section of our speaking to you. If you want to send questions through to me, please do so as I speak, and I will dish those out as appropriate when I have finished my short piece on logistical challenges. So as I said, you can either click to send those through to everyone or just pick me, Caroline Andresier, in the drop-down and send the question to me and I will farm out. So logistical challenges, what are we up against here? Document production. Okay, very first thing, all those documents that we used to sign and put in place, if we're all consigned to working from our kitchen tables, how are we going to produce them? I'm going to consider two scenarios quickly here. Firstly, the scenario where electronic documents, electronically signed, will do. And then to stop and think about in what situation the document production becomes a whole lot harder because we need hard copy original documents with wet ink signatures. So first scenario, document production. Many more documents than perhaps we usually do so in the real estate industry can be electronic in form, by which I mean soft copy documents, emails back and forth, and signed with electronic signatures. And electronic signatures cover a whole range of options. We're used to platforms perhaps being referred to as such as DocuSign, which is encryption, but actually an electronic signature can just as easily be typing in your name or writing in your name using the pen function straight onto screen. A signature is anything that shows you are bound. So an electronic document with an electronic signature may well be just what you need. So that would cover things like sale agreements, rent review memos, concession agreements, anything that doesn't need to be wet ink signed, an electronic document is just fine. Hard copy originals, though, are going to be needed where we need wet ink signatures, and here we're really talking about documents that are dispositionary documents, such as leases or transfers or charges that have to be registered at the land registry. Just because of these extraordinary times we find ourselves in, the rules have not changed. For a transfer or a lease or a charge to be registered at the land registry, we need the wet ink original document. So document production for those kind of transactions is going to be considerably harder. Now, fortunately, and I would hope it was the same for plenty of you, Evershed Sutherland have a network of offices across the UK. We have a skeleton staff still working in every office where we can, and it may be that even if your particular contact can't produce a hard copy document like they usually do, then a colleague somewhere else can. So document production for hard copy physical documents is a challenge, but hopefully one we can overcome. Right, my next point on this. Signing methods. Again, we're dividing between electronic signatures and wet ink signatures. And as I mentioned, an electronic signature doesn't have to be a sophisticated DocuSign. It can be typing your name in or drawing on the screen or something like that. So actually, when an electronic signature is suitable, it doesn't become an issue of whether you can sign, it becomes an issue of who can sign. And I would hope that signatories will stay safe and stay well, but if all we need is an electronic signature to an electronic document, then presumably the only impediment is if the signatories are sick. So possibly something to consider now is widening your pool of appropriate people who can sign your document. And you could do that through perhaps a power of attorney from your company to a wider list of authorized signatories. So electronic signing of electronic documents, it's a question not so much of where they are as to who they are and who can sign on your behalf. So widen that pool. For wet ink signatures, of course, you're going to have to get the physical document and the person and the pen in the same place. That might be more of a challenge. As I mentioned, the rules are still the same. If we're talking about a deed that is to be witnessed, now whether that deed is electronically or physically wet ink signed, it must still be witnessed. And the witness must be physically present when the signatory signs that document, however they sign it. Just occasionally, if you use a platform such as DocuSign, the metadata embedded in the document will show that the signatory attached their electronic signature at 2:05 in London and the witness appended their signature at 2:07 in Birmingham, which rather leads one to believe that actually there was no witnessing really happening. Witnessing by Skype or con call or something like that, that's not acceptable. You need a physical witness physically present in the same room as the signatory. Normally you would choose an independent adult, absolutely, but these are extraordinary times. You can grab any family member who may be around in order to witness your signature. Actually, technically speaking, they don't have to be over 18 as long as they know what they're doing, but I'm thinking, although I might go for family member, I'm particularly nervous about asking your children to witness, but, you know, witness in the same room at the same time, whether that's an electronic signature or not. And then from me as well, exchanges, completions and registrations. For exchanges of real estate contracts, for completion of real estate deals such as leases and transfers and charges, these documents, whatever form they take, have to be under the control of a solicitor. Inherent in a Law Society Formula B exchange or carrying out a completion under the Law Society Code for Completion in Post are quite a lot of solicitors' undertakings which make the world go round. If you send me the money, I will send you the document. We've exchanged, I'll send you my copy, you send me your copy. So those documents do have to be under the control of a solicitor. That's not to say that they have to be in the same room. I could be under, you know, controlling a document that is held by a colleague in a different office and I would be able to exchange. But it's important to remember that we still need to make that work undertakings and exchange-wise. The rules around registrations haven't changed. You're still going to have to pay your STLT within 14 days if necessary. You're still going to have to register at the land registry within your priority period. Fortunately, both those things can be done entirely online, so I'm hoping that that won't produce a logistical challenge for anybody. Okay, so that's what I was going to say about logistical challenges. I shall now start to scroll through the questions. If anybody would like to keep sending questions through, then please do. I shall just start at the top and take it from there. George, one for you to start with. Question to say from a tenant saying we would like to move from quarterly rents to monthly rents. How do we make that happen? So, George, if I've got a tenant who is actually trying to manage their cash flow in difficult circumstances, how do they make it happen that they move from quarterly rents to monthly rents?
Well, the starting point would be approach the managing agents, approach the landlord and ask for that. We've had lots of clients doing that, lots of landlord clients saying that they are being approached by people to do that, so it is certainly not an uncommon thing. And certainly we have not had anybody say to us, I've asked and I've been told no, is there anything I can do to force it? It always seems, in the current climate, people seem to be much more amenable about it. Usually you would document it just by a very simple side letter. We've had some clients saying, you know what, could you just draft us an email that we can send to people to confirm we're happy for them to pay monthly. So documenting it is very easy and straightforward.
Right, thank you, George. Lisa, a question that actually I sort of worried about, one for you here too. What about serving notices during this difficult time? I mean, if you're not there at your building to receive a notice, or if your landlord's not there at theirs when you try to serve a notice, anything we can do about service of time critical notices during this tricky time?
Yeah, it's for someone who has a client base who serves a lot of notices. It is a really tricky and difficult one. What most parties can legitimately do, and it constitutes valid service in most cases, is serve notices at premises that are the subject of the lease, even though that party is no longer there. So, for instance, if a landlord was to serve, let's say, a Section 25 notice at a tenant's business property and they weren't any longer operating that property because they decided to close that particular unit down, it would still be valid service. So even if a tenant decides to shut, wherever possible, it does need to go and collect the post. So that's the first thing. In terms of actually serving notices, again, the normal rules do apply. So some types of notices are governed by statute, some are governed by the terms of the lease, but you do have to follow that to the letter. So even if, for instance, you know a landlord is not in a particular building, you potentially still need to serve notice there if it is their registered office or if it is in accordance with the lease provisions. So you do have to carry on as normal, even if the party in question is not going to be at that premises. What concerns me more widely is being able to make sure that the notices get to where they should get to. And at the minute, there's very limited disruption to postal services or couriers or process servers, but we don't know what will happen in that respect. And I do know, many of you will know this, that, for instance, you can serve special delivery to arrive under a 9 a.m. service or a 1 p.m. service. The 1 p.m. service is gone now, so you can only do the 9 a.m. service. And I believe as well, the postal service are not asking for people to sign to acknowledge receipt. They can only confirm that receipt has been, that an item has got to its delivery destination. So we need to be very careful of things being able to get to places. The only thing I can say by way of practical advice is where you have instructions to go to your lawyers or agents to serve documents, provide those instructions as far in advance as you possibly can so that, you know, they can get there. And if there was postal disruption, you're not going to be subject to it, because that won't be, as things stand, unless the government legislates any kind of defence to failure to get a notice to where it should get to in time, for instance, a break notice. And if you wanted to serve a break notice to terminate a lease, break notices are construed and break clauses in leases are construed incredibly strictly. So if a notice gets to its destination a minute after it should have been, it won't actually operate to terminate the lease. You need to be incredibly careful and checking the lease provisions, thinking about the statute. My practical advice is serve as early as possible.
Okay, thank you, Lisa. And actually, Lisa, another question for you. And in fact, this I've seen several times from several tenant clients where they have entered into agreements to surrender, and they have at some point in the next few weeks to be able to vacate premises, you know, and that actually they are concerned about returning keys, about removing their stuff, you know, their people are long gone, but there's stuff about that. I mean, how can they surrender, giving up occupation, removing their things, giving vacant possession if they can't get to the premises to do it? What are your thoughts on that, handing back keys, actually clearing out?
Yeah, certainly on handing back. So if, for instance, you're under an agreement for surrender where either expressly or impliedly in most cases you've got an obligation to deliver up vacant possession, it is obviously important that you do so. You wouldn't generally, but it does depend on the drafting of the documentation, fail. The surrender wouldn't necessarily fail, but if it's conditional on vacant possession, then it would fail. Firstly, in terms of handing keys back, there is some helpful case law that just because you haven't handed the keys back doesn't necessarily mean you failed to give up vacant possession. But handing the keys back is probably not too difficult, because I would normally ask the landlord to confirm where they want the keys returning to, and if they don't confirm, I would post them by a secure delivery service like special delivery or recorded delivery to their registered office. If they're no longer at their registered office for any reason, that's not your problem, effectively. So that's the keys. In terms of emptying the premises, that's more difficult. Vacant possession there's a whole load of case law about that. Certainly, you need to make sure there are no people there. That shouldn't be a problem for anybody at the moment. The second thing is removal of all chattels. And if you fail to do that, that can be an issue. If you are choosing not to occupy premises, and as things stand at the moment, the government hasn't intervened to say you can't go into the premises, then you do need to empty the premises still of chattels, and you have got an obligation to do that. Then once you move away from chattels and you start looking at tenants' fixtures, generally speaking, an obligation to remove, to deliver up vacant possession, there isn't an obligation to remove tenants' fixtures. But there is one case in which casts some doubt on that, which there isn't time to go into today, but I just flag that. So what I would do is send the keys back, recorded delivery to the registered office of the landlord. Secondly, you do need to remove all of your chattels, and as things stand, from a government perspective, you do need to make sure you do that. I would also recommend that you contact your lawyer to check whether the surrender is conditional on vacant possession or if it's just an obligation. If it's just an obligation, the worst case is that the landlord can bring a claim, which probably would be insignificant in most cases for failure to deliver up vacant possession. But what you don't want to happen is if it's conditional, you lose effectively the surrender.
Okay, thank you, Lisa. George, one for you. We've had a question about the list of landlord services in a multi-let building and whether a landlord, for instance, could charge a tenant for the extra cleaning services or perhaps the deep clean of the building, or for that extra, what services extra can a landlord charge? What obligations has the landlord to continue to provide services in these difficult times? What can a tenant be expected to pay for?
Yes, so most service charges will potentially have a sweeper clause that would keep that, would potentially cover that. But equally, I think those sorts of charges could well fall under fairly standard clauses, such as keeping premises clean. Clearly, anything related to complying with statute, if it becomes an obligation to carry things out, would definitely catch it. So I think on balance, my view would be that tenants are likely to have to pay for those costs. But again, you would hope that landlords are likely to actually communicate with their tenants and reach agreement with occupiers of buildings as to what people are actually looking for. So if you have an office building and it's effectively being closed and no one's in it, then there doesn't seem a huge amount of point in spending a lot of money, extra money, in carrying out a deep clean, perhaps for a couple of weeks until things have progressed and we're getting more of a clear picture on what's happening. And I would expect the landlords would want to have those conversations. They'll obviously be concerned to make sure they're doing the right thing, but equally they're not going to want to spend money ahead of having buy-in from the occupiers that they're actually then going to be able to recover it.
Okay, thank you for that, George. Right, we're getting close to time, so I would just say if anybody has a question to submit, please put it through now so we can try and cover it before we finish. One question that I'm going to pick up, somebody has asked about whether the advice and issues and solutions that we are proposing today would apply elsewhere. Well, we've had lots of information and analysis in from our European colleagues, but safe to say, of course, that landlord and tenant law is not consistent across country, and it seems that in other countries, possibly tenants have it better than in the UK when it comes to rent suspension and the like. So if any of you have a particular question about premises in a particular country, then please get in touch with one of us and we'll put you in touch with our relevant worldwide colleagues. I've seen some documents in from our Paris office, from Austria, from our Munich office. The situations and the law are really quite different as we go around. So if you're considering a sort of pan-European portfolio, then we need to get you specific advice for each geography. One question here. A power of attorney for a tenant. Can I exchange an agreement for lease by simply typing in my name onto a soft copy of the agreement and emailing it to the landlord? An agreement for lease is a contract for a disposition of an interest in land. It's got to comply with Section 2, but we are as sure as we can be that simply typing in a name, an electronic signature like that would comply with Section 2 and that agreement for lease would be binding. Just a couple of months ago, we had a case that was only county court, so we can't really call it precedent, but that held that even just an automatic email signature footer was enough on a back-and-forth email chain to create a contract for the disposition of an interest in land. A signature is only something that you append to show that you intend to be bound. So there is no reason to think that typing in your name if you intend it to be banned, using your email footer by saying sort of many thanks, kind regards, all that would do. Right, Lisa, a question here to you. If we are a tenant, and George has spoken already about what we want to do if we want to move to monthly rent, is there any scope for tenants simply unilaterally moving to monthly rent?
Possibly. When you think about it, and going back over what we talked about before, the tenant does have an obligation to pay rent. So if it chooses not to pay rent in accordance with the pattern under the lease, and therefore technically is in arrears because, let's say, it's only paid 1 month rather than 3 months, and assuming the rent setter clause won't kick in, it does pose a risk for tenants, certainly. Tenants might choose to take that calculated risk on the back of advice, in particular, taking into account the commercial considerations of whether the landlord is likely to forfeit. In many cases, it won't want to forfeit in this current economic climate, and in some cases, the tenant may be very glad if the landlord chose to forfeit. So that may be a calculated risk the tenant is willing to take. There is a risk, as I mentioned, of what we call CRA, which is where a landlord can serve notice, and then after 7 days, if the tenant hasn't paid its rent, it can go to the premises and seize goods to the value of the debt. Well, if there are no goods in those premises that the landlord could take, again, the tenant may be willing to take that risk. Also, if the landlord serves with notice, the tenant could then choose to pay actually at the last minute. That remedy is not available other than on the standard annual rent, the main rent under the lease. It is not available for service charge, arrears, insurance, etc., even if they're reserved as rent under the lease. So if you were a tenant choosing not to pay something, you might choose not to pay service charge, so that remedy isn't available to the landlord. And the landlord has to give 7 days notice of that. Now, of course, that notice might be served at the premises, so if you're not occupying the premises, you need to make sure someone's collecting the post, as mentioned earlier in the question about notices. The landlord could also issue proceedings. You could then choose to pay if you wanted to, or see if you could come up with a defence, perhaps based on frustration, or the landlord has the option in terms of issuing a stat demand or winding up petition, but you may be able to get that set aside through various means. So it is a calculated risk that you need to take advice on and think about very carefully, but it is an option that certainly some tenants are taking when you look at the press in the last 24 hours, and they've obviously taken a calculated risk. And you might choose to use this as a lever to get the landlord to agree some kind of compromise.
Okay, thank you, Felisa. Right, we're coming up to 1 o'clock, so we will finish there. As I said, I will leave our contact details on the screen for a moment or two, so that if anybody wants to note down our numbers and our email addresses. Evershed Sutherland lawyers across the board, across real estate and real estate litigation, are all still working. We have been beautifully set up to work from home, from our kitchen tables, from our dining rooms. I had one partner yesterday give me a tour of his utility room, which had now become the quietest place in his house now that the schools had closed and he was hiding out back in the kitchen. So wherever you are, clients, we are still trying for you and wishing you safe and well through difficult times. I will end the session there. I will leave the slides up for a moment or two in case anybody wants to note down details. We would all be very happy to hear from you. Thank you very much for joining in.